So we've just talked about chapter 4 of part 3. That's the direct enforcement model. Just to be clear, there's some other stuff. Going on, and George set this out helpfully. But just to sort of remind people again, there are changes to the existing court-based civil model. So that's part 8 of the Enterprise Act. For those of you familiar with that, at the minute, that it essentially maps over the penalty powers. But in court, so both we, trading standards, and all the sector regulators can go to court and say, yes, we want you, court, to impose this penalty, but that's down to the court. Difference then than the direct model is that we would obviously make that decision in the direct model. There's some updates to the what we're going to call the unfair commercial practices. So those of you that are used to talking about the CPRs or the CPUTRs, the Consumer Protection for Unfair Trading Regulations, there's some updates to that. Just to sort of back up the point Hayley was making earlier about guidance. The next thing we're getting onto, and we're working on it right now, is to revise the guidance that we put out, that I wrote in 2008 on the CPRs. We're trying to get that out of the consultation before the end of the year, but there's quite a lot of work like this consultation and other things to do before then. But that's the ambition, to try and get that substantive guidance out for consultation in order for it to be in place ahead of the April commencement date that we've had confirmed in the written ministerial statement today. So that's the next big thing for me, I guess. And then there's a whole lot of other changes, and I'll talk a little bit about these in a bit more detail, but there's some rules on subscriptions, as we mentioned. Those probably won't come in until April 2026 or possibly even later. There's some rules on consumer savings schemes, and there's some changes to dispute resolution. I'll talk a little bit more later, but just to be clear that this is all happening at the same time. You can perhaps understand why we haven't consulted on all the guidance at once. Maybe that's for the best in terms of those responding to the consultation, but yes. I think we've kind of covered all this as well, but I mean, just to be clear, this basically kind of consolidates all of the Part 8 stuff into one space. So we had domestic and community infringements. We'll now have one set of infringements, and those are consolidated. So you don't have these kind of slightly weird, different definitions of consumer existing across different bits of law. So hopefully that will be helpful for everybody. Can apply to court for enforcement orders and interim enforcement orders, and I'm not going to explain the Part 8 regime, but that's roughly how it would work. You're effectively asking for an injunction. It's not exactly the same as an injunction or indeed an interdict in Scotland, but it's pretty similar. There's some online interface orders available there, and interim online interface orders, but I'm not going to spend a lot of time unpacking all of that. Effectively, the way that the changes will work is that the court has the ability to attach the remedies and the penalties to those decisions, but that will take place within the court system as opposed to through our direct enforcement regime. I've shared this before, I won't read it out again, but just about what applies to what. Our direct model only applies to the stuff in Schedule 16. The enhanced court-based powers apply to everything, but that's why we have to think about all of this at the same time, because the substantive law is changing at the same time, or roughly in parallel with the procedural changes, and that isn't ideal in some ways, but just that's kind of partly what I'm talking about today. Even if you're only interested in the direct enforcement, it's relevant to think about substantive law. So these are the kind of headline things coming out of Part 4. So Part 3 does all the substantive stuff, the court-based model and the direct enforcement model. Part 4 does what are the rules that those procedures are enforcing, updates the CPRs, as I mentioned. There's some specific changes to carry forward the government's consultation to prohibit the drip pricing of unavoidable fees. That's done through an amendment to the invitation to purchase concept, for those of you familiar with the CPRs. There is a new banned practice related to fake consumer reviews. That's also, that was a big headline issue that government talked about as the bill went through, and talked very much about these enforcement powers. And they did talk about fake reviews. So hopefully people have remembered that. There's some quite detailed banned practices, and we'll be putting some more details out on how we think those work in the guidance that I mentioned, whether that's end of this year or early next year. And then beyond those changes to CPRs, that's the top line. You've got some new rules around subscription contracts. That's still being worked on, expecting to come into force April 2026. We'll have a bit more time and more time for people to produce some guidance on that. There's some specific protections around saving schemes. So those of you that remember FairPack from over a decade ago now, collapse of saving schemes, it's a long-awaited response to kind of tighten up there. So there's some obligations on businesses that provide those schemes to protect the deposits effectively. and there's some enforcement powers for CMA and trading standards in relation to those. And then there are some changes around dispute resolution. Essentially, what that does is kind of map what the European framework from the ADR directive and its consequent consumer rights directive onto UK law. So it allows, for example, it allows the Secretary of State to nominate redress schemes rather than it being registered in the European Journal. So there's quite a lot of technical changes that needed to happen there, and a lot of that at the moment sits with Trading Standards Institute as the kind of backstop enforcer for the ADR scheme. So there's quite a lot of stuff changing in that space. I haven't got time to go into a lot of detail, but just to show you some, I won't read all of this out. We'll share the slides after the event, so you should see this, but just to go through that in a bit more detail. But I think probably in the interest of time, I won't read all of that. Happy to come back to any of these if anyone's got specific questions. But like I say, you've got the slides.